Hi, everyone. This is Joseph, and today we are talking about whether or not your green card can be essentially denied and you become deportable if you have a DUI offense. This is in response to last week's live where an audience asked about this bill that is going through Congress and got passed by the House already. I didn't know about it, and I usually don't comment on laws that haven't been passed yet. I mean, the whole goal of these live sessions is to talk about what's going on the ground, what people are concerned about, that the major news media is not talking about, that people are not seeing. But this week, we had a few consultations about this particular bill. People who have had DUIs, who are green card holders, who are thinking about becoming a citizen. And because people are concerned about that, I want to talk a little bit about it. And it's absolutely mind-boggling as I'm researching into it because it already passed. If it was just some bill that some intern in the White House or in Congress on Capitol Hill thinking about, that's one thing. If it's a think tank idea, I'm all for that, right? Thinking about playing with knowledge and debating about it. But this is something that is real and it is potentially going to be passed. Even if it is not passed in this current form, if Senate comes back and updates it or kills it, but it is there. Because again, the House already passed it with a pretty good majority as well. And so if later they're trying to bundle this into another bill, it could very well become reality. And the scariest thing about this particular bill is if you have a DUI offense, if you are a student, if you are a non-immigrant worker, if you're an H-1B worker, if you're a TN worker, if you are a specialty worker, if you are a green card holder, everyone other than a U.S. citizen, your ability to live and work and stay in the United States, you and your entire family, all the dependents, the privilege is gone. You're deportable, you're inadmissible. And so the nightmare situation we could see play out is you're traveling overseas on a 1 week, 2 week vacation. Suddenly this bill comes into effect. 10 years ago, you have this minor DUI on your record. You fly back into the country, the CBP officer at the border or in the airport says, sorry, this bill just got passed. Now you cannot come back in. We have to confiscate your green card. You're deportable. And guess what? You forfeit almost everything in the U.S. You have to hire somebody else, give them power of attorney, sell your car, sell your home, sell your cat, sell your dogs. Like you can't physically come back to the U.S. potentially for years. This is the reality that a lot of people are facing and people are inquiring about it. So I want to talk about this. One is to spread awareness so we can let our representatives know this is a pretty bad idea. Now, I understand why it is important and why the Congress, why the House has already passed it. It's very sympathetic. It is understanding, right? Because people have passed away in a DUI incident when somebody else was driving under the influence and they had prior DUI history. So it makes common sense to create a law that says if you have a DUI offense, then you should be inadmissible and deportable. I get it. You want to make America safer. This is one of the easiest things to do. Implement it, and bam, America could be safer, arguably. But here is where it gets extremely complicated, and we shouldn't necessarily do it. Because it doesn't distinguish between first-time offense, second-time offense. It doesn't, because this is a federal law. Right? Immigration law is a federal law. So whatever the state courts decide, whatever the arrest decides in that particular state or in that highway, that becomes a federal issue. And every state adjudicates DUIs differently. Sometimes it's a small fine with a stern warning. Sometimes it is very serious and you can get locked up. Different states, different municipalities, they have different regulations. But regardless of how each state implements their DUI laws, the moment it's on your record, suddenly ICE, suddenly CBP officers, suddenly USCIS, they get alerted And now whatever you're applying for, your green card renewal, your admission to come back into the United States, your registration with ICE, suddenly all of these things trigger. And so even though it was just a minor DUI offense on a freeway, now you're deportable and you lose your green card. Another major problem about if you get a DUI and you suddenly can lose your status is the very idea and framework of justice in the United States. If you are deportable or inadmissible, typically it requires a crime involving moral turpitude. It involves somebody being so bad that you get deported. And there are certain things, very, very small exceptions to this rule. For example, drug offenses, where it is so bad, we don't care about your mental state of the crime. You commit a drug offense, we will deport you, and it will become inadmissible. You cannot come back to the country. Now, if you open up DUI, driving under the influence, and if you put that into an exception, like regardless of your intent, right? Like, again, homicide, manslaughter, arson, like there's so many things that are really bad where you have to have an intent to commit a crime, and the United States of America designate you that crime as it is so bad under state law and federal law that we consider you a morally bad person, that we will take away your status. That has been the way immigration law is set up. Now, if you put DUI under this category, it opens up so many other doors. Well, what if you start running on next to a swimming pool? You're not supposed to. Oh, that's so bad that now we're going to deport you as well. Like, what other crimes is the United States going to start opening up so that people are inadmissible and deportable? One of the things that I love about the United States and the judicial system and the justice system is that it gives second chances. And this law sets a really big precedent in creating a two-class system. The United States immigration law is already very much a two-class system. There's the U.S. citizens, there's lawful permanent residents, there's the non-immigrants, and there's people who are not even in the country yet. They get different types of due process in each category. If you're illegally here, you're practically have no due process. If you're legally here on a visa, you have very little due process as well. For example, we saw the students who maybe had a traffic fine years ago, suddenly their visa gets terminated without any representation, without even much of a due process on the government's end. That was a horrible, horrible situation. And then if you have a green card holder, now because of a DUI offense years ago, suddenly you could become deportable, your entire family. That's the worst thing about this law, is that the punishment does not match the crime. It is so severe. You have a DUI offense that didn't harm anybody. It was a barely DUI offense. It was your first time. Suddenly, you lose your status, and your children who are U.S. citizens, your spouse who are U.S. citizens, everybody suffers. The entire family has to leave the country. That is a disproportionate punishment. A U.S. citizen who has a DUI offense, maybe 30 classes, maybe a fine, maybe community service, maybe even jail time to reform them, to rehabilitate them, to do all these things to make sure that they don't do it again. But for a non-U.S. citizen, you deport them, you erase their entire life. That is quite severe, and that is exactly what this bill does. Now, I am hopeful in our congressional offices that they are going to be wise enough to amend it so that it makes sense, that there's going to be exceptions. Maybe it's not the first time offense. Maybe it has to be a certain, duration where they have to be put in jail for a year because the severity of the DUI, then it triggers the deportability. But if it passes in this way, or even if it's a small adjudication, here's the unintended consequences. The CBP officers, the ICE officers, they might not know all the details. So when in doubt, Congress has passed DUI is deportable or inadmissible. They see anything in the record in the past 5 years, 10 years, 15 years, they immediately put somebody in proceeding. And because they're so swamped, they have such few resources. And for ICE, if they have a major quota that they need to meet and they're not meeting that quota, well, guess what? Instead of trying to attack and deport and enforce the law against major violent criminals, now they're going after everybody with just DUI offenses because it's a low-hanging fruit. Oh, you committed a DUI offense 10, 15 years ago. Doesn't matter if you are a green card holder. Doesn't matter if you're, been in the US and you're a high-end executive. You're an easy target. We know exactly where you are, and we can immediately serve you and arrest you and register you. Is that what we want as a country? Right? I get the point of we want to make America safer. I applaud that. But we have to make common sense regulation that matches reality, that matches what enforcement is able to do, and in order to execute it. Again, I don't know how it's going to turn out. I rarely comment on laws that have not been passed yet. But this is pretty important, and it's setting a precedent, and we could see what's coming. America wants to be safer, and they're going to implement a lot of more rules that are similar to this. So I guess the takeaway for anybody who's watching, who is listening, who knows about this, is if you are a green card holder, get your citizenship ASAP. Get it as soon as possible, because, and this is what I've been saying for years now, the rights and privileges of a green card holder is getting stripped down. It is becoming less and less valuable. In the past, being a green card holder, being a citizen, almost equal footing, with difference of being a citizen, you can vote. Some people don't even want to vote. Okay, then be a green card holder. But nowadays, green card holder is becoming just like a visa holder. It is on the path there. So if you have the opportunity, apply for that citizenship and secure that win before it is taken away from you.
So we have some questions from chat. Everyone feel free to drop them in. If you exit on an E2 while you have a pending 485, you come back as an L1, L2, is that I-485 application considered abandoned?
Wonderful question. It's amazing how good this question is. So let me start with the premise. If you have a 485 adjustment of status pending, you technically cannot leave. If you do leave the United States, the 485 is considered abandoned. There are a few exceptions to that. Basically the H visa, H-1B visa, and the L visa, namely the visas that allow for dual intent. And so those immigrant visas, you can have an intent to immigrate and be able to come back into the country. So basically the essential question is, you were on an E2 non-immigrant visa, you adjust status, and you've left the United States. Well, in a sense, you might have abandoned your 485. But if you're able to come in on an L1, you are basically admitted into the United States. You can come in and continue the 485. Here's the tricky part, and here's the part that USCIS officer might not quite understand, because were you on an E2, change to an L1, and then file the 485, right? Because if the 485 adjustment of status is based off of your E2, potentially that is considered abandonment. Okay, just want you to know that. L1 allows you to come back in, but the 485 might still be considered abandoned. So definitely kind of tricky, but if you're able to get back in an L1, hopefully this USCIS officer, the 485 interview, will still allow it to go forward.
Do you hire students on OPT?
As an exception. It is not the rule, right? We have plenty of OPT students, we have plenty of CPT students, but that is not our, we don't advertise for it. I know a lot of organizations do that, like they primarily depend on OPT or CPT. We try to make it extremely clear and fair, right? We don't have a separate program just for OPT and CPT. It's just the same internship application process. Everybody competes in the same way. Our internship is actually closed already. We really open it just for a short period during May to June. And then, so the next opening potentially is end of November, beginning of December, and we recruit for January if we have any openings. I don't know, hopefully that helps.
What are the rates for a dismissed controlled substance case?
What does that mean? What are the rates?
Approval rate?
Oh, okay. For what?
They had a controlled substance case and it was dismissed. So how will that affect the
Okay,
for a green card to get a green card?
okay. So I'm assuming you're lawfully here. You have a controlled substance case with the criminal court, and the case got dismissed. So there's no conviction. There's arrest, but there's no conviction. Now you're applying for a green card. You're filling out the 45 application. You're going to answer, have you ever been arrested? Yes. Have you ever been convicted? No. Explain the situation. You provide addendum. You explain everything. And now how will the USCIS officer decide, and will they give you a green card? Again, that depends on the circumstance. USCIS officers can and has denied green card applications and deported people even though there were no conviction. Why? Because to them, they have final authority. Maybe the state court didn't have enough evidence to convict you. Maybe they're too busy, so they didn't do it. But during their investigation process, based on what you said, based on what the document said, they don't believe you're a good moral character, and so they don't approve you. So pull your police record, pull the entire transcript of the court proceeding, have the DA provide a statement saying they didn't go forward with the charges, maybe even why they didn't choose to, because they believe you're innocent. That would be great. Have testimony, treat the USCIS officer like it's a judge, and win that case a second time. Don't just say, I wasn't convicted, therefore I need and I can get a green card. And then do everything else to show you are not the type of person to commit drug offenses. You're a good student, you work really hard, you're paying a lot of taxes, you do community service, you show your social media, prove that this was a complete misunderstanding.
My H-1B is ending and my employers aren't renewing, or they're not extending the H-1B, but I have an I-140 pending. Can I go on an F-1 without hurting my I-140?
The answer is yes. Let me teach you how. As an F-1 international student, you cannot have immigrant intent, but you have an I-140 pending. So officers, both USCIS officer, consular officer, and the customs officer, they might say, I clearly see you have an I-140 pending, whether it's EB1, EB2, EB3. It's pending. You therefore have immigrant intent. Your explanation, and you have to do your best to be able to do it this way. I-140 is somebody else petitioning. Somebody else really wants me. I just really want to study right now. This F-1 application, this change of status, this entry into the United States, 1 year, 2 years, 5 years, is to study. My intent now is to be a non-immigrant. Once it's done, I will leave. Prove that conclusively. Somebody else really wants me, but they may or may not get me years from now. That's their intent for me, not my intent for myself. We have used that plenty of times. It has worked. It's not a guarantee it will work, but you definitely want to do your best. And there's case law that supports this as well. So hopefully that helps.
Okay, my wife and son are both in Vietnam. We found the I-130, but the projected dates are 3 months different.
Okay, that happens.
Is that an issue or
no
problem?
Yeah, it's quite common. They process cases differently.
Risky to apply for AOS for U.S. citizens' parents if they are in the U.S.
Hold on, I just remember something really important. Can you tell Gabby that I can't do the Mexico entry tomorrow? That was pretty interesting.
Oh, we heard it all. Didn't say anything too incriminating.
Yeah. There's a really important connotation. Okay, sorry. Say the question again.
Risky to apply for adjustment of status for U.S. citizens' parents if they are in the U.S.
I'm not. I've heard the question like 3 times, but I'm not hearing why it's risky. So, do they have a problem? Or thousands of these cases are being filing every single day. Thousands of people are getting the green card every single day. So, I think if you do a case well, it's still doable.
Okay, I have done advanced parole with DACA. Do I need to give up DACA before I relocate out of the country?
when you relocate out the country, you don't give up anything. Okay, so you still have it, right? Now, I think what you mean is once you do leave and relocate out of the country, and let's say you're working abroad, you're going to try to get another visa to come back in, and your advanced parole expires, now you cannot re-enter the United States because you don't have an advanced parole that's connected to your DACA, and therefore you forfeit the DACA status that you had. That, I think, is what you're quote giving up. But you don't have to file anything. You don't have to tell the government, hey, I'm going away now, right? You just leave. You don't give away anything. Now, again, if you go and then you regret the decision, your advanced parole is still valid, you could get back in, and then your DACA will still be valid. Hopefully that helps.
October is my 1-year anniversary of being in the U.S. as a green card holder. How long do I have to wait before I apply for citizenship?
How long did you leave the United States in the past 5 years? Was there a question? No? Okay, so when you can apply depends on a lot of different factors. A lot of people, their main problem that delays their citizenship application is actually their travels. So if they travel too much, they can't apply within 5 years. If they traveled recently for a long time, over 6 months or so, that sometimes pushes it back based on the 4-year 1-day rule, right? So yeah, so it depends on your travels, and also if you have probation, we recommend finish your probation before you actually file for the green card. Citizenship. So if you have criminal offenses, if you have probation, you have convictions, if you have a lot of extensive travels, if you owe IRS taxes, pay for that first, get everything else done. But if everything is normal, then yeah, just file based on the N-400 instructions, right? Within 5 years, and then processing time about 9 months, interview 1 month, get your oath ceremony, naturalization certificate, and then you could get your passport within 3 days.
So you said he's married with no convictions or probation or anything like that.
Yeah. So yeah, totally file within. So the requirement is in the past 5 years, you need to be have a green card if you're not married to a U.S. citizen, right? So if you're married to a U.S. citizen, it's 3 years. If it's not, then it's 5 years. So yeah, you can file.
And how would you sum up that? How can I go on F1 without hurting my I-140?
Your I-140 will never be hurt. The concern is the other way around. Your I-140 will continue regardless of your F1 success or failure. You can wait outside of the country and the I-140 will continue to go forward. So I-140 will not be harmed by your F1. But it's when you try to get the visa, when you try to come into the United States as an international student, now this I-140, the officers will challenge whether you have immigrant intent. So you should be able to explain, I don't have immigrant intent right now.
How many U.S. citizens, if I owe back taxes, will that affect my wife and son's I-130?
I-130, most likely not. At their green card application process, it will definitely impact it. But that is in the past, right? In the past, we in a lot of I-130s, we don't even see major challenges with regards to bona fide marriage and, stuff like that. But nowadays, starting end of last year, this year, we're starting to see a lot of these challenges. So we are seeing the government challenge a lot more I-130s, not just based on, is this a real relationship, but do you actually meet all the other 45 requirements? So they're like pre-adjudicating the 45 at the I-130 stage. Is it good? Is it bad? There's a lot of debates about that. But if you're asking, will your back taxes affect your I-130 right now? We're not really seeing that yet, but it will for sure affect the 45 or NBC process later on.
How many U.S. citizens if I marry all of my girlfriends, can I give them all green cards?
If you marry all of your girlfriends, well, the U.S. has to legalize polygamy first, because you can only marry one person at a time. Now, maybe you're very creative and say, well, I can marry one, petition one, divorce one, marry another one, and we just cohabitate with a second one. Legally, immigration law-wise, that is possible. However, they also want to prove that your relationship is real. And now you really have the burden of proof to prove that you have a quote unquote marriage with each one of your girlfriends, even though you are sponsoring somebody else or you're still cohabitating with them. So it is a very big cultural issue. Maybe if you get a Netflix documentary on it and you can really prove the legitimacy of it, maybe it will be successful. But right now, you cannot because the U.S. does not allow polygamy.
Interesting. The poly, yeah. Very, very interesting. We haven't done one of those, have we?
Well, we can't, right? You can't,
right.
Yeah. Now, we oftentimes run into problems where somebody unintentionally became polygamous because they didn't realize that the previous divorce or marriage wasn't divorced. So that happens all the time. But in your case, you're more so, you have a lot of girlfriends, right?
Can a British person apply for an E2 in another country? There's lots of negative stories from London at the moment.
Read the question again.
Can a British person apply for an E2 in another country? Because there's a lot of negative stories from London right now.
It depends on if the other consulates allow you to interview without you living there. So, for example, Canada and Mexico, right? Most common, we see that. They are pretty swamped with the number of people applying themselves. So they do have additional room. They're also short on staff. They also cut funding. And the people in their own country is already waiting a year to 2 years for a B1, B2 tourist visa interview. They're already so short staffed. Are they willing to take somebody else from a different country to interview? Yes or no? A lot of times you have to ask each individual consulate. Now, there's certain consulates elsewhere in the country that are a little bit more free. There's not that many people applying. Then sure, they might accept it. So yeah, it's possible. You have to shop around to see who is willing to accept that interview.
Will filing a K3 speed up my marriage I-130? My spouse is in India.
No, completely separate tracks. They're not going to be related to each other.
I am 27. My wife is 45. We have an upcoming immigration interview coming up. Are there any tips you can give me?
You're 27. She's 45. Yeah. Okay, so that is a red flag because the woman is significantly older. If it's the other way around, not that big of a red flag. So the question is, treat your interview like it's the first time meeting the family. Is it a fraud marriage?
She's Chinese. The man is American as well. The wife.
Okay. So, well, I guess here's the question. Who is I guess both ways is hard. Yeah. So, okay. So I'm assuming it's the Chinese 45-year-old woman who is the immigrant here, right? Because you say you're American, right? So now the 27-year-old male husband, how did your family accept her, right? Imagine you're in the dining room and you're talking about this. How do you convince that this is a genuine relationship? Because everybody will have the same questions. Is it an immigrant? Is it a visa fraud? Is it a marriage fraud? Is she just using you? If you can convince your parents, surely you can convince the officer, but do your absolute best, right? This is about the TN. The TN visa category only applies to Canadians and people from Mexico. And USCIS, as well as the consulate, have been extra strict recently and with the new memos out about the TN process, making it a lot less lenient.
Okay.
And for people who don't know what the TN category is, I will do all of this actually in the success story. So for people who are watching live, this is what we're doing right now. We're going to live record a success story on a TN applicant and successfully got the TN under this new guidance. It was a very tricky case. Grace and her team are the ones who worked on it. So I'm going to be interviewing her and talking about it. And this is, again, recorded live. We're going to make the live success story into a separate video that we'll post so you guys can see later. And then I'll explain all the process. So today's story is about a TN visa. We're extending it in the United States, and I'm here with Grace, who did the case. And the reason why it's so important is because TN is under a lot of scrutiny, and with the new memos, they're adjudicating it and making it much more strict. In the past, TN visas, you can make a lot of creative arguments to say the U.S. really needs this occupation, really needs this job. It's in short supply in the United States. The TN visa category is meant to fulfill the job market needs. And for example, in this case, we're talking about engineers.
Yeah.
In the past, lots of things are engineers. Software engineers are engineers.
Mm-hmm.
But the new memo is becoming much more strict. Well, are you really an engineer if you're a software engineer? The original intent of the engineer is like the mechanical engineer. Our client is not a mechanical engineer. So how do they qualify as an engineer? Because any CS degree, or not CS degree, any STEM degree, you can try to argue as an engineer. But again, the world is moving at a very fast pace. A lot of things qualify under engineer. Immigration law is tightening and becoming more strict. They want to meet specific guidelines. And again, who's adjudicating? These USCIS officers, CBP officers, visa consular officers that are not aware of every single occupation under the sun. So in this changing dynamic where things are becoming more strict, the world is moving at a super fast pace. Companies and individuals who previously got TNs, and how do they renew it? All of it is in flux. They need a really good immigration lawyer to kind of guide them through the process. This is a success story on how Grace and her team was able to get it done. And I don't really know that much more about it than what I just said right now. So, well, go ahead, Grace.
All
What happened?
right. Well, yeah, I guess we can give a little bit of context. So June 4th, I believe it's like the same day that the White House issued the travel ban. There were a lot of different updates that happened during that time, and TN update was one of them. So it wasn't a legal change, but it was a policy change, as I just mentioned. So you wouldn't have known unless you looked at the policy manual. I didn't even get a press alert for it, actually.
Yeah.
And so, they try to be subtle, saying that they're just reinforcing things that are already in the policy, but actually there were quite a few changes. One is that they explicitly banned self-employment. Not that self-employment was ever really allowed under TN, but arguably you need an employment contract and show a bona fide employer-employee relationship, which we've done for other visa categories, right? Like O and there's always E. And so it explicitly says that you can no longer do self-employment TN. So if for all of you who are currently on TN, where you have ownership in the company, it's probably time to relook at that structuring before you renew it. It also says that you cannot have a TN through a foreign employer, so it has to have a separate U.S. entity, so no foreign branches can do TN anymore. Mm-hmm. So like Canadian companies, right, might have a U.S. presence, they might have been able to do a TN, no longer, right, as of June. And I think the biggest news, at least for my team, is that they're starting to also narrow down the scope of what is included in these occupations, right, because not everyone, unfortunately, can apply for TN. There's a list of occupations that are allowed under TN, and the ones that were affected, engineers, as I just had mentioned. So traditionally, computer engineers with a CS degree would be under this category. No longer you have to have an engineering degree or a license, right? And it specifically refers to ONET. So now we have to look at what are the ONET. And, in the law, it doesn't actually say what the degree has to be in. It just says degree. But now it's explicitly saying it has to be directly related. So it's almost like an H-1B interpretation of TN. Same with computer systems analyst. If you're just programming, if you're just testing, you're no longer qualified under the computer systems analyst. I definitely recommend looking at the ONET job duties and seeing if your job actually falls under that. And those are the two actually we're looking for this case. And then the other three are economists, right? So no more market research analysts or anything that has to do with market or business that we might have been able to get under economists, no longer. Scientific technician and technologist. So now you can't have, before you might have been able to get like a technician under like a physician without doing direct patient care, but that's not allowed anymore. And then also physicians, it has to be teaching and research only. So it's also a more narrow view of what you can do as a physician under TN.
A lot more strict, for sure.
Yes, so. That's the summary, right.
So that's the background. This came out.
Right.
What happened to the client?
Because our client was actually already in the U.S. on a TN.
Okay.
I think she had it already twice. So, right, we're like routine extension. Didn't think it was going to be as complicated. And then this came out, and she happens to be in engineering classification. So we really had to go back and see what was submitted the first time. She did it at the border, but this time she wanted to do it before USCIS. And another thing that was actually explicitly mentioned in the policy update is that the adjudication by USCIS and CBP should be aligned because generally speaking, CBP had less of a review because they're reviewing at the border, right? So they're flipping through papers, whereas opposed to an officer at USCIS has time to review all the documents, could potentially do an RFE. So typically, it's a lot harder to extend your status in the U.S. or to change of status. We'll see how it is, right? So anyways, she wanted to extend it in the U.S. And so we had to look at her job duties. And because the employer, very well-established employer in financial services, but she didn't really do a traditional engineering discipline, right? So we had to really think, how can we align her more as an engineer? And we also studied her degree because her degree actually was in applied science, but it was from the School of Engineering. So we had to make sure it was very clear that she does have an engineering degree. And typically, I don't do degree evaluations because it's not required. But in this case, I did because I wanted to show that she does have a U.S. equivalent of an engineering degree. So that's the first thing we did. And then we looked at all the different ONETs and what she was doing because she's overseeing products, right? And how to create this project and manage this project and the processes behind it. There's a lot of engineering principles that are involved. That's more akin to an industrial engineer. So we had to argue that an industrial engineer is not just at a factory. Of course, that's what they can do, but also do things that are intangible, right? So we had to talk about all the different services that could be done through an industrial engineer, not in a physical, tangible way, but, like, for example, financial services. So, and we also had to provide some work products that we thought were in line with what an engineer would be able to do. So that was a little difficult, but actually we were able to find a couple of work samples that, kind of showed the context. And thankfully, the case got approved.
It sounds like you're doing an H-1B case.
Right? I felt like I was doing an H-1B case too. So
everything you did for the TN, you really just went and borrowed from how you do H-1Bs.
That's right. That's right.
The evaluation, work samples. And those are typically not things that we need to do for TN at all. We've done tons of TNs.
Absolutely.
I love that. I love how we are able to use different case categories. And that's what immigration law is, right?
Yeah.
It's the same USCIS officer, same think tank who's thinking about, well, how do we improve different visa categories? So like TN, well, let's make it more like H-1B. EB-2 and IW, let's make it more like EB-1A. EB-1A, let's make it more like EB-2 and IW. And so if you're good in one category, that knowledge can potentially help other categories. Now, it'll be a total overkill if you did the H-1B on TN for all the other previous cases. But nowadays,
you might have to.
It's part that's where TNs are going.
And we're trying to walk a fine line because I want to help the adjudicator to approve the case, but I also want to make it clear this is not an H-1B case, and this is what the minimum that the law requires.
Right.
So when USCIS sometimes is overstepping, right, we have to also educate our officers and say, actually, the TN doesn't require a specific degree, right? So I'm not looking to explain that it's a specialty occupation. I'm just saying this is a degree in a related field.
Right.
So I'm like trying to give a lot of information, but also trying to make sure we stay in the lane of what a TN is for.
Do you think it's going to be easier once this TN is approved at USCIS and then we go to the border?
Yeah, that's true.
Because USCIS is technically more strict.
Yes.
But CBP likes to hold their authority. It's like, just because USCIS approved it, doesn't mean I'm going to approve it.
Correct. Right. So the next time she enters, we're going to have to make sure she understands how to present her job so that it is that it qualifies for engineering. She might get more questions, right, and more scrutiny at the border.
Right.
And she's going to have to take everything with her.
Right.
Okay.
Well, thank you, guys. If you guys have any questions about TN or really anything employment-based, Grace is right here. You guys get a very, very few opportunity to ask your questions. So, yeah, any questions?
Okay, let me look for business questions.
Oh, yeah.
What's a common route for a child who would age out of the E2 visa?
Oh, that's a hard one. If you're aging out of E2, I guess it depends. If the child is still in school, there's always a change of status to F1. And if they are able to get a job at a nonprofit related to a university, you could try H-1B cap exempt since this year the cap has already been filled. Or if they're somehow able to I guess it depends on when the E2 expires, right? Because if they're able to wait until next year, you could try the H-1B lottery.
Or you inherit the E2 from the parents. You start your own E2 as a child.
Yeah.
Those are one of the most common things. Yeah.
Can I have my employer sponsor me after I've been sent back to Mexico for coming illegally into the U.S.?
Oh, coming illegal into. So employer sponsorship, actually, yes. But I think the question is, will you be able to use that employer sponsorship to get status in the U.S.? I think that's the hard part to see if you're going to be admissible. So, yeah, I guess it depends whether it was a permanent bar or whether it was a time bar, right? So if you're able to adjust your status or if you're able to get a waiver to adjust your status, then yes. And the actual employment sponsorship process, you can start that now if you'd like while you're in Mexico.
That's right.
Okay, we don't have any other employer or business related.
Sure.
A lot of questions about DACA and stuff like that.
Sure.
I relinquished my U.S. citizenship 10 years ago. I have Belarusian citizenship. Can I get my U.S. citizenship back?
Through green card and then through
In
citizenship.
5 years, yeah.
Yeah. So you can go through the whole process all over again.
What kind of background checks does immigration perform when you apply for immigration status?
It really depends on what kind of status you're applying for. So if you're applying for a basic visa, like a F1 international student, or if you're applying for a tourist visa, the consulate does their own set of background checks. If you're applying for a green card, then there's going to be criminal background checks. That is a lot more extensive. And then if you're applying for citizenship, obviously they dig a little bit deeper, right? And oftentimes involve FBI. So depending on what benefit you're getting to be in the country, they will do their corresponding background checks.
I accidentally put no for if I was ever cited. Can I tell them and then bring the disposition and receipts?
Yes. So typographic.
Highly recommend.
Mm-hmm. Yep.
What kind of testing do they require upon applying for a marriage green card? Like, do they do blood work?
Medical exam?
Maybe you're talking about the medical exam. So, and that's not done with USCIS. You go to a doctor's office and there's a set number of civil surgeons that do your tests. So they do the test and the doctors send in their report, right? USCIS is, they're not experts in medical, but if the doctor says you're fine, usually they approve it.
So update on the Mexico potentially inadmissible. Their previous employer is the one who was responsible for, or is in the process of sponsoring, and they have their interview in October. Is there a chance that they can get their green card? How do they know if they're admissible or not?
So they're already in Mexico?
Yeah.
So the previous job, or there's a company that sponsored them and they have an interview coming up.
Yeah.
I'm assuming the interview is overseas in the consulate and not in the United States.
Or it could be in the United States, because I think he's asking if he can come back to the interview.
I see. If it's in the United States and you don't have legal status in the United States, there's no way you're going to be able to get your green card. So don't illegally cross, go to the interview, just get deported. If your interview is overseas, then it depends on, well, how long is your wait time, right? So potentially you already waited 5 years, 10 years, because the I-140 process and the NVC process is extremely long and you already waited outside. So when you go to the interview, you really want to prove, hey, this employer still wants me. They are willing to offer me my job, even though it's been 10 years. They like me a lot. I'm really good. And I've been waiting and I qualify now, right? So, yeah.
Do F1 student nurses still need a 4-year degree to get the EB3 visa or associate's degree? Does that qualify?
That is a good question for Grace.
Student nurses. The only thing I would have to double check if there a separate requirement for nurses, but I mean, typically for EB3, right? If you have a minimum of a bachelor's degree or at least 2 years of experience, it's a professional occupation. Or if it's less, for example, an associate's degree, then you would be under the other workers category under EB3. I don't know if the answer is, but
Yeah.
Are the nurses or medical immigration employment visas still being processed, or are they changed?
that I'm not actually
To the best of my knowledge, it is still the same. It is still a high demand. There's nothing that I've read that says that it was canceled. That is still
NIW position, J1 position. I don't think there's any changes.
Okay, E2 child follow-up. Is getting his own E2 viable considering he will have 0 work experience?
Yeah, well, we've done plenty. Yep, people who just graduated college and then get an E2. Yeah, I can name, I don't know, like 10. I mean, if you go on our YouTube channel, go under E2, you'll see plenty of success stories. You know, this girl who started like an anime patch, somebody who started like a lighting company, you know, decorating Christmas lights and Halloween lights, so many things. So yeah, you don't have a job experience, but if you have a good mind, you have a good business plan, you're well supported, well funded, you know, you have a good education. You know, Nike was started in a garage. Look how big that is, right? So prove to the officer that you're capable. If you're not capable and you're going to do a terrible job at the interview, well, then it's not really your job experience's fault. Dude.
If your charge or conviction was amended to non-criminal charge, like a traffic ticket, can you still be deported?
And again, USCIS, CBP, ICE, they don't have to rely purely on the end result of the criminal trial. So even if it was dismissed, even if it was expunged, even if it was dropped, they could still deport you if they're able to muster up a case to prove against you in immigration court, right? So again, the burden is on them. So obviously, if the case was dropped, it was amended, it was just a citation, it's much harder for them to prove you are deportable, you are a terrible person when the case was dropped. Mm-hmm. However, if you're just asking for possibilities, they have all these other reasons that they don't like you. They can just drag you through the process to make you self-deport if they wanted to, right? So just know that's their bandwidth.
Okay, work visa, potentially inadmissible follow-up. They deported them in this July, and the interview is not in the U.S.
Okay.
They were deported in July.
So if you're deportable and you got deported, you most likely need to get a waiver. So even if you do apply for a green card overseas, the consulate will deny you because they will say you're inadmissible and you need to file a waiver. So then the question is, do you qualify for an immigrant waiver, which is very different from the non-immigrant waiver? Mm-hmm. And an immigrant waiver requires an immediate relative who is a green card holder or a citizen. So you want to look into the 601 and the 212. So just ChatGPT it. 212, 601, what is the immigrant waiver?
Can I renew LPR with a DWI misdemeanor that happened 7 years ago?
DUI?
Yeah, it's a DUI.
Oh, now, yes. Based on my news story today, if Congress passes, you might not be able to.
I filed an I-130 December 2023, filed expediting, which was denied. When do you think I will hear back? What's the current processing time?
I-130?
Yeah.
Depends on your case category. I like the category as well.
1 year, 2 years?
Mm-hmm.
My boyfriend has a speeding charge that has been closed. Will that affect him when applying for green card?
Most likely you'll be fine.
My wife's case has been in NBC from last year, 2024. Is that too long or?
Very common. NBC takes slow. But definitely want to follow up. Maybe make sure they send. NBC sends emails to the wrong email addresses all the time.
They do.
So definitely follow up.
Send a public inquiry. You can find it on their website, and that's the best way to contact them.
Yeah. The year is getting to the point where it's time to be concerned.
Pre-trial diversion with no guilty plea in not a conviction for immigration.
One more time. Pre-trial
diversion, no guilty plea.
Okay.
Not a conviction for immigration?
Does that consider it?
So
I guess
it goes back to what we were saying, right? You have the arrest is always on your record.
Mm-hmm.
They will always see that arrest. It's on every background check that's going to happen.
Yeah.
So the immigration officer is going to see that and then start asking questions.
Okay, this is a follow-up on the DACA advanced parole.
Uh-huh.
Parole, they want to adjust that if they're a parole entry married to a U.S. citizen.
Right.
Yeah.
Should they file the I-130 first before they file the motion?
I-130
to reopen a root case.
Right. So I-130 you can file at any time. The 45 is the one that's a little bit tricky.
Mm-hmm.
It's best to really come down and strategize. It doesn't have to be with us, but with anybody. Typically, you want to file the I-130 first, and then you want the motion to reopen, and then you would do the 45, and you file the 45 with the court, and then goes to USCIS. That is a typical way. I have seen in this year, this administration, people are so concerned and so scared that they would rather do the I-130, the 45, because you qualify for it based on the advanced parole. But then you take it and you show the court and then have the court terminate and bring it over. Every court is different. You know, you might be spending extra money because you might be forced to pay 245 fees essentially. So I know that's a lot of things that I just said. The safest thing for sure, hands down, what you could do, just I-130, you could definitely do that. Doesn't confer any immigration benefit, but at least you have that in. So the only question is where you should file the 45. Different attorneys are going to tell you different things. Motion to reopen in 45 with them, or directly file 45 with the USCIS, and don't even open it with the immigration court, which we've seen rarely work. Sometimes it works. Most of the time it doesn't work. So I don't know. Hopefully that helps.
Okay, we'll take 2 more questions. What can I expect on my first entry as an L2? Do I have to prepare or explain anything?
The most important thing is that you need to come after the L1. A lot of people don't know that. And we've seen plenty of L2s get denied and turned away. Because the L1 is the main person who's supposed to come in the country to work. But a lot of L1s are busy abroad and they want to send their family and children to come first. And that little tiny mistake of who enters first is devastating. So that's the main thing you need to worry about. Now, if the L1 already came in, you come in as L2, you have your basic documentation, you have your original receipts. That's what they really want to look at, you know, and then you can answer some basic information. That's all that's required.
If I choose to do a consultation with you guys, can you help me do my CBP entry case?
So we try to do as much as we can during the 250 consultation. We, share your screen, talk to us about your situation. We'll treat you like an intern. We give you as much feedback so that in that session, you're fully equipped so you can help yourself. If at the end of that session, you still really feel like you want to hire us, then we give you a quote, right? But our job during the consultation is not sales. We're not trying to pick up any more cases. We already have too many from all the different teams. So during the consultation, it's just really our public offering. Ask us your questions, show us your concern, and we try to give you as much feedback as we can. You don't have to hire an attorney and law office for every single thing. So if we can do it on the spot, help you out, you save money, spend it on your family, good for you.
And then final thing, can I renew LPR with my DUI misdemeanor that happened 7 years ago?
Right now, yes. If Congress passes the DUI deportability law, no.
And our final question, after applying for the E2, can I enter the U.S. on an ESTA while the E2 is pending?
E2 is typically done overseas. So I guess your question is, if you apply for E2 and before consulate adjudicates it, you fly in on ESTA. The answer is very rarely, because most of the time you find out the answer immediately. So that scenario rarely happens. But I guess...
But maybe when you're preparing for an E2, if you need to do some business in the U.S., I could see that in limited circumstances.
Right. Maybe you're preparing for the case, you already submit the S-160, you have 3 months before your interview. Right. You fly over here a couple months and you fly back. That's possible. Okay. Thank you guys for watching. Right. I hope you guys really enjoyed Grace. And, leave some comments. Let her know how awesome she is. This is the first time doing live with her. So, thank you.
And then if you guys want to book a consultation, you can always find us at our website or check out our other channels.
Thank you. Take care. Bye.
Bye, everyone.